Welcome back, everyone, to Let's Talk HR. As I said at the beginning, Let's Talk HR is the newest addition to the Let's Talk Business South Carolina network of B2B talk shows. As always, I'm your host, Rick Jenkins. I'm glad you found us. Herb Dew, who is the CEO and founder of HTI, is still with us, and now we are joined by Jay Silvers. Jay is an attorney with the law firm Ogletree Deakins. Now, Ogletree Deakins, big law firm, 59 offices, 31 states, doing business throughout the country. This guy, Jay, you work out of the Greenville office. Is that correct?
I work out of the Greenville office. That's right.
I want to talk to you about two things basically today. These are two big legal battles that have been going on for a while. I think both of them started back in April of last year. Both of them, there was some regulation that came down. Both of them were overturned in August or September of last year. And I want to get your thoughts on where we're going to go from here. And I want to start with the non-compete clauses in employer contracts. Now, as I said, I think it was in April that FTC, or the Federal Trade Commission, passed a ruling to prevent non-complete clauses in employer contracts. Now, that's a big deal. That was a huge deal, and I know that because I have had them my entire life, and I know that's a big deal. First of all, tell us about how it started.
Yeah. So the FTC, as you can imagine, it changes with administrations. And the last administration really concerned about protecting employees. This administration will see what's going to happen. So the FTC gets involved and says, you know what? I think we're going to get involved with the non-competes. And South Carolina employers aren't really restricted that much from a regulatory or statutory standpoint with non-competes. Other states, they are. California, you can't have non-competes. So the FTC gets involved and says, you know what? We're going to pass this rule. And they did it.
Yeah. Herb, how often do you talk to folks where this is a real issue, whether that be employees or employers on the opposite side of it?
I mean, frequently. I mean, all of my employees are covered by non-competes.
Yeah.
So it's not unusual to have those. And, some are just protecting confidential information. Some are more restrictive and protecting customers and that sort of thing.
Right.
But this is a conversation. I'm glad we have Jay here because this is a conversation point that comes up an awful lot. And they ask me, and I'm not an attorney as Jay is, but what to do about their non-competes, what's happening with their non-competes. I think they're concerned about there not being any structure so that somebody can take trade secrets and move somewhere else and take those trade secrets with them. So yeah, I think there's a lot of conversation still about what's going to happen with that.
So at your company, how many employees you have?
180 internally.
So you've got 180 employees, and all of them, or at least most of them, I'm assuming, depending on maybe the job they're in, have a non-compete clause in there.
They do.
If all of a sudden, and it doesn't look like that it probably will go through, but we'll get to that in 1 second. If all of a sudden you had to remove those, how much consternation, sir, would that cause you?
Well, it would probably cause me more consternation with my sales group and people that are sort of, developing customers, the rest of the employees. I mean, we've always been pretty good about if somebody's going to leave, we're not going to stand in their way. And you have to be careful with non-competes. I guess Jay would admit to this. I mean, in our case, our non-competes are not very restrictive. They're just protecting our customers for a period of time, or like 1 year. So we're not stopping them from working in their industry.
Right. Regardless, it got overturned. It got overturned in August or September. One, why was it overturned? And two, what are the chances that it be overturned again?
Well, it was overturned because the district court in Texas, so you don't have this rulemaking. You don't have the authority, FTC, to do this. This is not within your purview to pass this kind of law or this kind of rule. So it was overturned. And they also said some of the evidence that the FTC relied upon was not good evidence. It was bad evidence to even say that we needed this.
Gotcha. Let's move on to the second legal battle we talked about, and is the reclassification of exempt and non-exempt employees. The ruling, I'm going to read this here to make sure I get it right. It said higher salary thresholds that employers would be required to pay employees to maintain overtime exempt status. However, the rule again also struck down. Before we get into it though, just make sure that we all know the difference in an exempt and a non-exempt employee, sir.
That's a great thing, Rick. So most people think, I'm salary, I'm non-exempt.
Yes.
Well, that's not necessarily the case. You have to pass certain tests to be exempt or non-exempt.
There's several questions you answer, and if you answer them this way, it determines.
That's exactly right. And so when you're not exempt, you're not subject to overtime. And when you're exempt, so if you're non-exempt, you can work 75,000 hours in a week, and you're still gonna get paid your salary.
The original Department of Labor ruling, what did it say?
It said it was going to go for executive, administrative, and professional employees. They were going to take it from basically $38,000 a year to $54,000 a year. And then they were going to take the highly compensated employee from $107,000 a year to $154,000 a year, something like that. So it's going to make a big difference for a lot of people as to whether they want to get overtime or not.
Right. And why was it struck down?
It was struck down because the court said, listen, you guys don't have the right to do this. You didn't go through the proper steps procedurally, and you have some data that is incorrect as well. So the court said, no.
And have you noticed trends of companies that are moving from one to the other, trying to reclassify?
So I know in our case, if we had to implement the $53,000 threshold, because we have an awful lot of people that are paid variably. If you're recruiters or you're sales reps, you have a low base, but you have a really high upside on variable. But they were only that exemption was based on your salary, as I recall. So we probably had 50 employees we might have to reclassify as overtime eligible. That should not be. They're in roles that they would not be normally.
Yep, I hear you. Jay, what are the chances that either one of these come to fruition, either the way they were originally structured or in some other alternative way?
I think over time, especially with the exempt, non-exempt, it's going to go up. Is it going to go up in the next 4 years? I don't think so.
Yeah.